The latest hearing in Donald Trump's classified documents case has been unfolding all day in Florida, where the former president is charged with 31 counts of illegally holding on to some of the nation's most sensitive intelligence. Each count is related to a separate document found at Mar-a-Lago, including 9 marked secret, 21 marked top secret. That's the highest level of classification. The key question before Judge Eileen Cannon today: how much of that information can be turned over to Trump's defense team, and how much should stay secret? I want to bring in NBC's Katie Fang outside the courthouse in Fort Pierce, Florida. Jamil Jaffer is founder and executive director of the National Security Institute. Charles Coleman is a civil rights attorney, former prosecutor, and MSNBC legal analyst. Good to have all of you. So, Katie, where do things stand with this hearing, and have we seen Donald Trump at all?
Well, Donald Trump arrived this morning with his defense team. He met with Aileen Cannon. It was supposed to conclude at 2 o'clock. We've been waiting to see that caravan of SUVs leave the federal courthouse behind me. And starting at 3 o'clock, special counsel Jack Smith's team gets to meet with Aileen Cannon without the defense side being present, to be able to handle some of the remaining issues that are outstanding from when special counsel Jack Smith met with Aileen Cannon on January 31st. Now, Chris, CIPA, which is the Classified Information Procedures Act, and I'm thrilled to see that Jamil Jaffer is there. CIPA is very specific when it comes to process. And this Section 4 hearing that's taking place today is a part of that particular Classified Information Procedures Act. But what's interesting is the fact that Donald Trump himself arrived at the courthouse today to sit in a courtroom with the judge that's presiding over his criminal case without the prosecutors being present. In addition, though, his co-defendants, Walt Nauta and Carlos de Oliveira, were explicitly not allowed to appear today, but their lawyers were present. And so there was going to be back and forth between the defense attorneys and the judge explaining their theories of defense. And then again, this afternoon, the government will meet with the judge to explain why certain classified documents should either not be turned over at all, or perhaps in a redacted or substituted form.
So that's the heart of it, right, Jamil? So explain how this judge balances Trump's right to defend himself with those national security concerns.
Well, this is exactly one of the challenges in classified information cases, and it's what the law is designed to do, is to allow the defendant to see summaries of the documents potentially, but not the documents themselves necessarily. At the end of the day, the question is, did the president know the documents were classified? Did he retain them? Did he do so willfully? And did he fail to turn them over when asked to do so? And so knowing what's in the details of the documents or not may not really be material to the ultimate underlying charges, but that's what the judge needs to suss out. How much of the defense relies on what's inside the documents, how classified they are, and how sensitive are they, and should the government be able to protect them from a defendant? This is one of the hard things about prosecuting any case involving highly classified information. This would involve some classifications at the highest levels possible.
I mean, this is at the heart of, to me, the commonsensical part of this, Charles, which is, can you convince a jury that something egregious happened here that should be criminally prosecuted if they don't know what it is that's in those documents?
I think you can, Chris, but I think that one of the things that people are not considering here is the X factor of Aileen Cannon as the judge. I think that she's already shown that she has her thumb on the scale and is very amenable to the arguments that his defense team is making around the notion that we need to know as much information about these documents as possible. And make no mistake about it, that's very intentional, because what they're trying to do is they're trying to put enough pressure on the prosecutor to make a decision about what they decide to put forward in terms of their Section 4 plan under CIPA that Katie was talking about. So all of this is a game of chess and strategy, and Aileen Cannon is the variable that people have not accounted for because of her tendency to play toward Donald Trump and his defense team in their arguments. But under normal circumstances, yes, you very much so could do that, because as Jamil talked about, you don't need to talk about the specifics of the documents to establish the counts. But to your question in front of a jury, it then becomes an inquiry around, why does this matter?
Yeah. And Jamil, explain why the defense believes that they need access to these documents. And, you know, we're coming off the Super Bowl, like the GDP of a small nation was bet. So what do you think the chances are that they will ultimately get access?
Well, you know, I think they'll probably get access to some of the documents. Their argument is going to be, in order for the president to understand part of his defense and be able to make his defense, which may be in part that he declassified the documents, or the documents were never properly classified in the first instance, and therefore he did nothing wrong by retaining them, right? They're going to want to be able to see those documents to be able to make those arguments. The challenge, of course, is once they get to see the documents, there's a question whether they'll be presented to the jury again and whether they'll be made public. And oftentimes defendants in cases involving classified information will engage in what's called gray mail, which is an effort to get the government to drop or reduce the charges based on the fact that highly classified information might come out. CIPA is designed to prevent that, as Katie and Charles both laid out, right? And the question now is, what's the judge going to do with it? She's meeting with Trump and his team separately, then with the prosecutors, ex parte in cameras, they call it, behind closed doors, with just one party there. And so we'll see where she comes out at the end of the day. And of course, if either side is displeased, they might be able to take up an appeal to the 11th Circuit, as has happened before in this very case.
Yeah, in a gray mail case that was involved with Oliver North, who was that's a very famous name from back in the 80s, they actually dropped some of the most serious charges against him, right?
It is something that has been effective for defendants in the past, because it does put prosecutors in a very unique position. You have to make a decision about how important are certain documents to your charges and to actually getting a conviction versus what is pleading the case, what is building the case. And I think that this is exactly the space that they would like to put Jack Smith and the DOJ in, which is why in this Section 4 hearing, they're going to hammer home, look, we need to see everything. We need to have all the details. We need to have all the information, because the idea is the more we ask for, we may not get everything, but we will get enough, hopefully with this judge, that it will make Jack Smith's job very difficult. And he's going to have to make some judgment calls as to what he leaves in, what he leaves out, and what he decides to compromise around.
Is this a situation, Katie Fang, where he'll make a decision, we'll get a written ruling, will it just be announced in court? How's this going to play out?
Yeah, so Chris, it's going to be a written ruling because it cannot be announced in court, and that written ruling is going to be the subject of a potential interlocutory appeal. CIPA provides in a specific subsection for an expedited appeal. So for those of us that are watching the timeline of all of Trump's trials these days, if Jack Smith is unhappy with Judge Cannon's rulings, then Jack Smith's team can take an immediate appeal that is provided for as right. I would mention very quickly, Chris, before I say goodbye to you guys. There is also a move by Donald Trump to get access to the actual Section 4 filing itself. So what do I mean by that? So Jack Smith had to file a Section 4 filing under seal, submitted to the court. Donald Trump actually wants his hands on that document. That is unusual because contained within that filing, Chris, is a sworn declaration from the intelligence community explaining why each particular piece of evidence that is classified information is classified, why it's so important, and why it reaches those very elevated standards of being protected and guarded. And so the judge today is also hearing arguments from both sides as to the merits of whether or not Donald Trump and the other defendants in this case can actually get their hands on that Section 4 filing.
Katie Fang, Jamil Jaffer, and Charles Coleman, thank you all so much.